I am Mike Merrill. I'm County Administrator for Hillsborough County, and thank you all for being here this afternoon. The reason for asking you here today is to announce the discipline for the 4 fire medics that were the subject of the July 4th event resulting in the death of Crystal Galloway. So let me just start by saying the only purpose, in fact, for paramedics, the only reason paramedics exist is so that they can bring every tool that we have and every bit of experience they have to a scene to help the patient survive. That's it. Our residents and our visitors, everybody who calls for help, deserves to have both of those. They need to know they're getting the most complete service and the best service. I believe that our fire rescue personnel as a whole are committed to both of these values. But on the morning of July 4th, Crystal Galloway received neither complete care nor the best care from the 4 fire medics who responded. So today I have issued discipline to all 4 fire medics. They have all been served this afternoon. You probably have copies of what was served to them, but just in summary, Lieutenant Mike Morris, who was the fire medic in charge of the scene, acknowledged that he was in charge of the scene, is terminated. We have Acting Lieutenant Barton, who has received a 30-day suspension without pay, and she will not be able to function as an acting lieutenant for at least a year, and she'll have to go through extensive retraining. Justin Sweeney, who has served a number of years as a fire medic and who was the individual who spent the most time at the bedside of Crystal Galloway, is being demoted to firefighter and receiving a 30-day suspension without pay. The final individual, Martin, who was the junior member of fire rescue on that call that evening, is receiving a 30-day suspension without pay. So those are the charges that have been, the discipline, in fact, that's been levied on all 4. They have all been served. I will say that the process has been extensive. We have spent 10 weeks looking at this. We brought in outside legal experts, medical experts to help us process this. I've given these 4 individuals multiple opportunities to explain why this happened, to help me and help the community, help the victim's mother understand what went wrong, and they chose not to take advantage of those opportunities. And in fact, one of the factors that weighed heavily on me as I made this decision, putting, in addition to their failure to deliver service and follow clear protocols that laid out without a doubt that vitals are to be taken in all cases. But the other factor was the lack of remorse, and in fact, in some cases, outright arrogance. That weighed heavily in my decision to terminate Lieutenant Morris, who said he would do the same thing over again, and that he doesn't need to take vitals. He knows by looking at a patient. That's unacceptable. So any fire medic and any firefighter who wants to work in this department and be one of my employees needs to understand they will take vitals, period. They don't have the authority, they don't have the right to make an assessment of their own based on looking at a patient. If they're not willing to accept that directive, they need to find work in a different department. So I believe that after 10 weeks, after looking at this from all angles, after giving all 4 ample opportunity to respond and to help us understand. This has not been a rush to judgment. But at this point, I think we've exhausted all of the tools we have, all of the effort that we can expend, and I felt it was time to bring this to a close. And so with that, I'll be happy to answer any questions you have.
I know the findings against the paramedics that the county found initially.
Mm-hmm.
The mother made some claims that they actively tried to dissuade them from taking the ambulance. Did the county ever substantiate that? Was that true or not?
That's a good question. No, there was no evidence or substantiation that our paramedics, that the 4 paramedics in any way tried to dissuade the mother from allowing them to transport her.
And was there any indication that race was a factor, as she indicated?
No, and again, I'm glad you brought that question up. That was one of the things I asked my staff to look at, and we did an extensive search of calls in that area for a number of years, and found that the calls spanned all races without issue of transport, without issue of care. And we can provide that data to you. So there really is no evidence that we have been able to find that would indicate race was an issue.
Is it possible that Crystal Galloway would still be alive if they had taken the correct steps?
That's not something that I can certainly speculate on, nor any of the medical experts that we talked with. There was no autopsy. We know what the cause of death was, but in a certain sense, it doesn't really. It matters. I don't mean to say it doesn't matter. It matters because she died, and that's tragic. But what really matters is it's not really an issue for a paramedic to take on themselves a decision of whether a patient is going to make it or not. Their obligation is to take vitals and assess with all the tools they have to make the right decision about care and about transport. And so if a patient's on death's door, it doesn't matter.
But she would have had a better chance. Do you agree that she would have had a better chance had this been done properly of surviving?
I can't really speculate, but I would say she would have had a much better chance than she had.
And do you expect a lawsuit from the family?
I'm not sure. We haven't heard.
You haven't heard, or you don't expect one?
We haven't heard, and I'm not going to speculate on whether we expect one.
The mother has asked that all of the parties involved were terminated. Do you have confidence that the 3 that were demoted or suspended or taken their acting lieutenant, that they will protect the community? Because people see this and say, well, there's 3 still out there that didn't take vitals. Are you confident that they'll be serving the citizens with the safety and security that you expect, that they will follow protocol?
Right. So that was probably the most difficult part of the decision. And so I'm going to talk about that a little bit because I think it's important. The way that the system works, it's a system that I didn't create, we didn't create. It's a system that is imposed on us, is one that involves binding arbitration in cases like this. So a dispute over discipline doesn't go to a judge, it doesn't go to a jury, it goes to a paid arbitrator. And that was the reason, not that I don't have confidence in our legal staff, they're extremely good, but we were all so close to this. I wanted to bring in someone from the outside to take another look at it. And so I really had to weigh the issue you raised. Is it a strong enough message to the 3 and everyone else in fire rescue to drive the point home?
I don't think it's a message. I think it's just a fact.
A fact.
You're going to lose sleep at night.
Right. The second part of it is it going to send the right message? Is it going to give the residents confidence that when someone shows up, they're going to get the best service? All of that has to be weighed against the risk, and it is a real risk, that an arbitrator won't agree with the discipline that's been meted out and returns not just 3, but all 4 of them back to their original jobs with full pay and full status. That's the way the system works. So based on that decision, based on those circumstances, I feel that where we ended up is a good place. It's a strong place. It sends a strong message. It should give people comfort. This is serious discipline. I mean, termination is, of course, but for the other 3, that's serious as well. And
Can you clear up the lack of remorse statement that you made? Was it just Lieutenant Morse, or was it all 4 that had lack of remorse? Or just the lieutenant that was fired that had that?
initially, Martin, who was the junior, in his written statement, did express remorse, or expressed that he thought things should have been done differently. But interestingly enough, everything after that he said in the pre-disciplinary hearings, in the interviews, he never once again made that statement, which I have to assume was because of coaching and collaboration, which is too bad, because I think he had it right the first time. Other than Martin, none of the others even had a shred of remorse, a shred of regret, a second thought. Morris in particular, though, was extremely arrogant. The fact that he said he would do it again the same way, and that he can tell by looking at a patient what they need, I think is horrendous. And so that weighed heavily in my decision to terminate him.
This idea that they don't...
Is there any concern that, by his statement that he didn't mean to take vitals, you can tell that attitude or ideology is pervasive through Hillsborough Fire? Are there others who maybe would think the same thing?
In my heart, I believe that, as I said, we have a very good fire rescue team here, and that they do value the patients, they value their work, and they do follow protocols.
But what would have led an entire group, not just one person, but a group of people to say, we don't need to take vitals?
Yeah.
Did you ever figure out the why?
That's what I was hoping, by giving them the opportunity that they could not only shed light on that for the sake of the family, for the sake of just discipline, but also to find out if there were any other training types of issues or other changes that needed to be made so it wouldn't happen again. But unfortunately, they never were forthcoming, and so I don't know the answer.
And one of the issues at play here was perhaps some confusion over the 911 call coding. I believe it was a dual entry where they could say patient wasn't found or patient wasn't transported. Have any changes been made to that system?
No changes were needed. They had every tool they needed. So we are not stressing that charge as part of the discipline. It's there. What we want the arbitrator to focus on is the clear, unequivocal failure to do their primary mission, to take vitals, which is what everyone wants, everyone expects. But no, they had all the tools. That was just made up stuff.
I want to go back to just the idea of whether she would have made it had the folks who responded differently. Is there any way, as far as you can tell, to determine, I mean, you said there's a better chance she would have, but is there any way to determine whether her death was caused by this lack of proper response?
I don't believe so, no.
You don't believe there's
Yeah.
And did you consult with, I assume you consulted with medical staff and maybe a medical examiner and things like that?
Right, we did. We of course have our own medical director who's contracted, but then I did ask for an independent individual with extensive experience in emergency medicine and also overseeing other fire rescue departments to take a look at it. But because there was no autopsy, there's really no way to.
And why was there not an autopsy?
I don't know. That was the decision that was made by the hospital, by the attending physician at the hospital.
Should there have been one?
That actually is outside of my scope. That would be handled by the hospital. hospital, and she was in medical care when
Yeah.
she passed away, so typically an autopsy is not done unless it's the request of the family. So that would be a question for someone else outside of Mike.
Yeah.
Is that a hospital decision or a medical decision? No.
Well, initially it's a hospital decision. There are certain requirements in statute for certain types of injuries that automatically
Right.
get referred to a medical examiner. But as Leanna said, that I think this one would have been within the domain of the hospital.
And I have another question about your statement that you believe that the paramedics were given every opportunity to help you understand what
Mhm.
happened here, and they didn't fully take advantage of it.
Right.
Apart from perhaps being arrogant or not giving the right
Mhm.
answers to some of your questions, were they cooperative? Did they provide information when asked, or was there any difficulty trying to get through this process?
Well, so the process, they had 4 opportunities. The first was a written statement, so clearly that would have been their own work. The second and third opportunity would have been pre-disciplinary hearings, in which really they just have an opportunity in front of a hearing master to just state or restate or add to whatever their original written statement was, right, without questions. So those 3 really are not opportunities for us to ask them questions, to probe, and so forth. So it was really the last step, which were interviews with 2 investigators from our HR staff, where there was a back and forth, and there was an opportunity to probe. And no, by that time they had pretty much clammed up, and it was clear they'd been coached, and there really wasn't any useful information forthcoming.
I know you didn't really want to stress the part of their findings that they falsified the documents,
Mhm.
but did you ever figure out if they actually refused the ambulance or in any way discouraged that? I know they didn't get the informed consent like
Right.
they were supposed to, but the main charge that led to their discipline is that they didn't take the vitals.
Yes, that's correct. No, there's no evidence that they the 4, in any way tried to dissuade the mother or the patient from being transported.
But they at the very least should have gotten the informed consent.
Definitely, yeah, right.
Could you describe again
Mhm.
the reasons for the differences in the level of punishment
Mhm.
that were laid out?
Sure.
And I guess the follow-up to that is, if someone died,
Mhm.
why were any of their jobs spared?
So let's take them one at a time. Lieutenant Morris was the person in charge at the scene, and he acknowledged that, and as did the other 3. So it would have been his responsibility overall to ensure that vitals were taken and that all the proper protocols were done. And so that places him in a particularly, So that, to me, in addition to the other factors, clearly warranted termination. Justin Sweeney was the fire medic who spent the most time with Crystal Galloway at her bedside. He had been a fire medic for 5 years. He was clearly trained. All of them had acknowledged the training they'd gotten was more than adequate. He knew how to use the life pack, take vitals, and there was plenty of time for him to do that. And so because of that interaction or that attention to the patient and lack of duty, I felt that he should be demoted and also receive the suspension for 30 days without pay. I'll go to the junior member, Martin, who, although he was junior, still had been a firefighter for a few years before becoming a fire medic, had all the proper training, and really each individual takes an oath. Each of them are trained on the protocols. Each of them has an obligation to speak up if they think that something's not going right at a scene, like not taking vitals. So he, even though he's junior, he really is not absolved of responsibility under his license, under his oath, and that's why the 30-day suspension without pay. Barton, as acting lieutenant, bears more responsibility, although she was not in charge of the scene. So I believe that a fair discipline for her would be the 30-day suspension, but also not having the ability to be an acting lieutenant for at least a year.
Are you going to be sending out a memo of some kind or something just beyond this news coverage that says you've got to be taking vitals if you're a member of the staff? Retraining, in other words, for the entire department?
I should. Yes, I would hope it's clear, but yes, probably should do that. Yes, absolutely.
Is there any this discipline? Is it final? Or is there a appeal process for these three individuals?
It is final, and so the next step would be for any or all of them to decide to appeal it to the arbitrator. And in that case, it is binding arbitration, as I said, and that's dictated by contract, by other things outside of my control.
So the
statute.
arbitrator makes the decision about the punishment, and they also appeal directly to the arbitrator, who can essentially change their mind based on their appeal?
Mm-hmm. So an arbitrator can restore them all four of them. So if all four appeal it to arbitration, the arbitrator could reject all of the discipline and return all four of them to their jobs at full rank and full pay. That's an option.
Is that a person appointed by yourself or by the county?
No, actually, Rudy, can you describe how that happens, or Beverly, or?
So the arbitration process is through a grievance.
Spell your name, Rudy.
It's Rudy Hadermota, R-U-D-Y. Last name is H-A-I-D-E-R-M-O-T-A. So the arbitration process is available to any bargaining unit employee represented by the International Association of Firefighters, and it starts with a grievance that is filed internally with Fire Rescue Management, goes to the county administrator through the HR director, and ultimately it's a final and binding arbitration in front of an arbitrator. So that's how the process works. The employees have to elect to file a grievance, and the management team is obligated to process that grievance, and at some point in time the union has to decide whether they want to appeal the case to arbitration.
Thank you. Speak at all, I mean, we were all here maybe about a month ago now when union representatives were here, and there were hundreds of firefighters in the county center ready to show their support for their fellow fire medics. What effect has this whole ordeal had on the relationship between yourself, between your staff, and the fire department? And are there any measures to maybe improve that relationship or make some changes moving forward?
Well, I guess you have to begin by understanding that at least the way that the union representatives, union leaders see their job, it's to help save jobs. I don't agree that that's their only job. I think their job is, yes, to help save jobs, but it's also to maintain the integrity of the service. And sometimes that means that people need to be disciplined. So I don't know that, given where they are in terms of what they believe their job is and where I am, that we'll ever agree on that. However, I do believe that, as I said, that we have very good fire rescue personnel, and in my heart I believe that they all want to do the right thing, and they do in fact do the right thing. Goes back a couple months ago now, I guess. I offered to the union to hire an outside consultant to come in and help both management and labor fire rescue employees work through any issues that might be there. And so that's been underway. They've self-selected a steering committee, representatives of both management and fire rescue. And that will be an even-handed process that will ferret out concerns, issues, ways to make things better. And that's my hope, and the union is supporting it. So.
And for the family, for Crystal Galway's
Mhm.
family, has the county reached out to them at all, or yourself? Is there anything that you could say to them,
Mhm.
or maybe want to say to them
Mhm.
after, there's, I suppose, an admission that
Mhm.
there was some fault?
Sure. Yes, we did reach out to them. I offered to Ms. Black the opportunity to come in and talk to our investigators, to share her, her views, her side of the story, as part of the overall investigation. She elected not to do that, which I can understand. And so, as I did initially, I do sincerely apologize and heartfelt apologies for our lack of care and service. I hoped and had hoped that, as I said, the 4 fire medics would have been more forthcoming and owned this. At some point, I think it would have been good had they apologized themselves instead of me, but someone has to do it, and I do it with all sincerity. I don't know what that means, but I'm done. Thank you again for all coming out.